Right. Good morning to everybody, and welcome to everyone who's dialed into Espresso Briefs this Friday morning. We've got two fantastic guests this morning, Professor Jon Patricios and Advocate Nick Ferreira. Both have CVs longer than my arm, so I'm going to give you the condensed version of both of them. Jon is a professor at the Faculty of Health Sciences at the University of the Witwatersrand. He is also a consultant to World Rugby, to the Springbok rugby team, to the All Black rugby team, and to the NFL in the United States, amongst his many other accolades. And he's one of our leading sports science physicians in South Africa, and I think it's fair to say is our leading expert from a physician point of view on concussion in South Africa. Together with Jon, we've got Advocate Nick Ferreira. Nick also has a CV of distinction. He was a Rhodes Scholar. He's got a DPhil from Oxford. He's one of our leading public lawyers in South Africa, and also one of our leading sports lawyers in South Africa. And I've got a great pleasure to welcome both of you guys this morning. We're going to be talking about a topic that's very close to my heart, which involves sports, anti-doping, head injuries, and refereeing and officialdom, and the consistency of all of that. So let's start off on anti-doping, which is really a very topical topic at the moment. South Africa, unfortunately, for various reasons, is at the forefront of some of the anti-doping stories recently. We've had an under-20 rugby player whose sample A tested positive. We've also had one of the members of the senior Springbok team have an issue from a doping point of view. So this is really a very topical issue. And the issue of doping at high school, in our high schools, is also really an important issue. So I'm going to start off with Jon. Jon, can you just give us an overview of sort of how anti-doping works in South Africa, and just can you explain the role of the South African Institute for Drug-Free Sport? They're obviously at the forefront of anti-doping in South Africa, and can you just give us a bit of an overview of how the system works? And can you also explain why there is no testing at schoolboy level, apart from sort of Craven Week and these specific tournaments? Why don't we have testing on a sort of regular basis at a high school rugby level? But Jon, over to you.
Thank you, Anthony. Thank you for the invitation, and it's a pleasure to be here with Nick. So in terms of anti-doping, the principles involved are really threefold, and that is that the South African Institute of Drug-Free Sport, which oversees doping control in this country, is there to firstly help look after the health of the athletes, because some of these agents which they may be taking may be harmful to their health. The second is to prevent cheating. And the third is really to help protect the spirit of the game in various sports. And they play a central role in that. And it's really part of a global network of drug testing agencies that's under the supervision of an organization called WADA, or the World Anti-Doping Agency. And the South African Institute of Drug-Free Sport is a statutory body appointed by the government and has to align with the highest international standards in terms of doping control. And they do that by applying their practice in a very strict fashion in terms of the athletes that they test, how they conduct those tests, and where they send those tests. It's very strictly regulated according to international guidelines. Now, in terms of professional sport, every professional athlete in the world has to subject her or himself to the prospects of testing under the World Anti-Doping Agency's regulations. And that might be under three sets of circumstances. So one may be random testing. So, for instance, if you present at the Commonwealth Games, they might have the local drug testing agency there to conduct random tests on some of the swimmers, athletes, netball players, etc. Some of it may be what we call targeted testing. So there may be tip-offs about athletes who have been suspected to take certain drugs, and then they're actually deliberately targeted, and that can be a knock on the door at 6 a.m. and they're subject to testing. And increasingly, that testing is what we call intelligent testing. So there are trends that are monitored by the various drug testing agencies around the world. Those trends might be in tests that have been submitted over time and trends that are noticed in the types of readings on those blood or urine tests, or they may be trends in performance, where, for instance, a weightlifter has been noted to suddenly increase his or her performance, and that testing is then becomes more targeted. So it's a very, very intelligent and information-led process that takes place, that's regulated worldwide. Of course, it costs money. So the national agencies have a budget which they're allocated by their government, and they're responsible for allocating that budget across all the sports in the country, which then answers your question as to why some tests are conducted and why not others not, because they have to obviously select who they're going to test, and they will choose largely those sports where doping is likely to be an issue regarding performance enhancement, or where their intelligence leads them to believe that doping is taking place. And that would largely be at the professional level. At the schools level, there are a couple of issues. One is the lack of funds, and the second is issues around testing of minors. You know, whether you are allowed to walk into a school and test a 16-year-old without parental permission, etc. Ethically, it becomes a little bit more challenging in terms of instituting those procedures. But nevertheless, at the youth weeks, as you pointed out, that testing takes place. Now, increasingly, the sports bodies, for instance, South African Rugby, would have handed over the responsibility totally to the South African Institute of Drug-Free Sport, SAID, so that there's no conflict at all. So the independent agency conducts all the testing on whom they want, when they want. And there are calls to institute that sort of testing at schools level, and perhaps we can discuss that further. But hopefully that gives you a little bit of a background as to how this is conducted. It's a very organized, systematic, and internationally consistent process.
Jon, that's really helpful. Can I just ask you one follow-up before we come to Nick? South Africa used to have our own laboratory for testing drug samples or potential drug samples in Bloemfontein. That accreditation was revoked, I think, in 2025. And now all of the samples of South African athletes get tested overseas, whether it's in Qatar or Belgium, etc. Can you just explain the process that happens to an athlete who gets tested in South Africa and what happens to their samples?
So the athlete has the test conducted, which is typically a urine test, and it's conducted by representatives of SAID, South African Institute of Drug-Free Sport, who conduct it in a very ethical way. The athlete signs forms giving consent to the samples being tested. The sample is then divided in front of the athlete into what we call an A and a B sample, which they sign off on. In other words, they acknowledge that the sample is one that has been split. And the reason for that is that if there's an issue with one sample that's tested, the athlete has the option of having the B sample from the same specimen tested. That is then sealed and transported in a very monitored and audited fashion to one of the accredited laboratories, which comes to the point that you're making that used to be in South Africa in Bloemfontein is no longer. They lost their accreditation because they didn't meet the auditing criteria any longer. And now it has to be transported not just out of the country, but out of the continent. We no longer have a laboratory in Africa, although we are working on re-establishing that. And so it goes typically to Doha. Other options are Belgium or Barcelona, and that has significant cost implications. It doesn't have implications in terms of the testing, which is uniform across the globe, but in terms of cost, They're now significantly higher, probably 3 to 4 times higher, which then has implications on the number of tests that can be conducted on a single budget. So that has had implications in terms of our ability to penetrate across various sports and the number of tests conducted.
Thank you. Nick, let's talk about the legalities of all of this. The South African Institute for Drug-Free Sport is a statutory body established by an Act of Parliament. And they apply the WADA code, the World Anti-Doping Agency code, and essentially that has a strict liability component to it. So in other words, it's a no-fault type of regime. It doesn't matter what the excuse is. If your sample comes back positive, unless you've applied for some sort of therapeutic exemption up front, if your sample comes back positive, basically you're going to be in difficulty. Is a strict liability standard problematic from a South African constitutional perspective? And secondly, does any of the anti-doping hearings that take place in South Africa under the auspices of the South African Institute for Drug-Free Sport, are those regulated under our Promotion of Administrative Justice Act? And can you talk a little bit about the legalities of all of that?
Yeah, sure. So, a strict liability regime means that it's not necessary for the regulator to show that the athlete was at fault for the prohibited substance getting into their system. So it's possible that that substance could have got into the athlete's body without them even being aware of it. And yet they can still be held liable because it's not necessary for them to have had any form of intent or negligence in order to be held liable. So that's the nature of a strict liability regime. The purpose of it really is to create uniformity, because remember, WADA is a global body and they are imposing a regime which governs national and regional sports bodies all over the world. And so what they want to do is to create a system that can be as certain as possible and as uniform as possible across all those different jurisdictions. And they want to create a system where the athlete has ultimate responsibility to take every possible measure to ensure that what goes into their body is not on those prohibited substance lists. And so it seems there are probably quite good policy-based reasons to have a strict liability approach. It doesn't mean that fault never comes into it. It then gets considered again at the level of sanction, because you can then argue that you had no intent or it was a pure accident. And one thinks here of Yannick Sinner's case, for example, where his masseuse gave him a massage with some cream which contained a prohibited substance, and that was taken into account at the level of sanction, that there was no intent on the part of the athlete. Whether it's constitutionally problematic in a South African context, I mean, there's no strict South African constitutional rule against civil strict liability regimes. In other words, our constitution doesn't require that fault be an element before you are held civilly liable. One could notionally challenge the regime on the basis that it limits a fundamental constitutional right. It's not very easy to think what the rights would be here. Maybe your right to practice your profession, because as an athlete, you might be precluded despite having no fault. But I must say, if you were to ask me which side of that argument I would prefer to be on, I would certainly prefer to be on WADA and the Institute for Drug-Free Sports side, because I think you could put up fairly compelling policy justifications which explain why that limitation is reasonable and justifiable, given what they're trying to achieve and the regime they're busy trying to create.
Can I also ask you one allied question to that, which is about onus of proof? I mean, essentially, once there is a positive finding, the onus essentially shifts entirely to the athlete to, either demonstrate that there was a fault in the way in which the sample was tested, or to demonstrate some of these mitigating circumstances which would justify essentially a lesser sentence. Do you think from a constitutional perspective in South Africa that there are any issues around the way in which the onus issue is dealt with under the WADA code?
Again, there, I think you could make out quite a good defense of the reason for casting the onus in that way, because who is the person who has direct, intimate knowledge of the circumstances in which substances enter the athlete's body? It's the athlete and the athlete's team. So to put an onus on the regulator to establish how the substance came into the athlete's body and that it was deliberate, it would make it impossible. Because how would WADA or the South African Institute ever be able to get that kind of evidence? So it seems to me, again, it's defensible. It does make it quite difficult for an athlete who has received a positive test on their A and B sample to overturn a finding of liability. One way in which it can be done, quite a good example, is the example of Ludwig Mamabolo, who was stripped of his Comrades Marathon title on the basis of a positive test back in 2012. And what his lawyers did was they went really forensically through the pre-test protocols and established in that hearing all the ways in which the Comrades procedures had departed from quite strict protocols about chaperoning the athlete after they cross the finish line, ensuring that the athlete isn't consuming substances. I mean, in that case, for example, Mamabolo was given, I think it was 2 or 3 unsealed Energade drinks by people who were just kind of passing it to him over one of these kind of plastic barriers before he was tested. The chaperones weren't properly qualified, and they came up with 15 or 16 of these things. And the argument there was that the reason for those strict pre-test protocols is exactly to balance out the harsh effect of this onus of proof that the athlete bears. And if the race organizer cannot show that those very strict protocols were strictly adhered to, then it's unfair to impose that strict burden on the athlete. So that's really where the kind of litigation work would seem to focus. If you're seeking to challenge it, it would be on the pre-test procedures. But it seems to me, again, to place the onus on the athlete is probably the only way to make these kinds of hearings work, because WADA certainly can't lead evidence as to what was put into an athlete's body and when and why.
Jon, we've talked about the legal standard, which means that it's really important for South African athletes to know what they can and they can't take. And obviously, if you go into any shop out there or online, there are ranges of supplements and all sorts of other substances. And we know that there is massive pressure these days on schoolboy athletes to get bigger, stronger, fitter, and all of these kinds of things. How do they know what supplements and substances are lawful and safe to take, and how do they know which ones they shouldn't take? Is there a guide that you can suggest in this regard?
Yes, let me divide it into different categories. So the first is obviously that of deliberate cheating, where you go out and you seek something that you know is almost certainly performance enhancing, and you take that deliberately, or you have it injected deliberately. So the most common example would be anabolic steroids, which is a deliberate attempt, and I think there the line is clear that it's quite black and white. One shouldn't do that. And, most of the cases we see are actually deliberate cheating. The second might be medication use, where there's a medication that you're taking or want to take or prescribed that may or may not be on the permitted list or banned list of substances. And WADA has an extensive list of those substances, which they update annually, and that is published. Now, I think it's probably burdensome to expect the public, sports people, and particularly young people, to go and check that list, which has an extensive list of names, generic names of drugs, which most wouldn't understand. But in this day and age of information access, there are apps that you can search the name of your drug. And in fact, South African Institute of Drug-Free Sport has made this very easy on their website. They have a very easy-to-use app. You put the name of your medication in. So let me use a commonly known one, Voltaren, for instance. You'll put it in there, and it will come up with either a green, it's permitted, or red, it is banned strictly, or orange, it is permitted out of competition. Again, coming back to Nick's discussion on strict liability, it's then up to that athlete to check and double check and triple check with his doctor, pharmacist, medical team around the team that this is so, and make sure that that is a permitted substance. In certain cases, those medications might be on the red list, but you can, if they're really required for medical purposes, seek what is called a TUE, or therapeutic use exemption, where your medical team can motivate for you to take that medication. An example might be insulin for diabetics, or medication for ADHD, for instance, where there are very strict processes in place for justification for taking that. Now, the third, probably the murkiest area, is that of supplements, sports supplements. And there are a myriad of sports supplements out there. So I always joke, when you walk into the big discount pharmacies to cash your prescription for the antibiotic, the hardest place to find is the dispensary, because it's usually tucked at the back of the pharmacy. And that's a deliberate commercial ploy, of course, because you walk through rows and rows of supplements before you get there. Now, which one do you buy as a sports person, which you feel will give you an advantage without compromising you in terms of legality? And that is very difficult, and has been very difficult until recently. So I found this a real problem with my patients over the last decade. So what we've done is we've worked very hard with pharmacy groups now to have certain commonly used supplements, for instance, proteins, carbohydrate supplements, and creatine, verified in terms of their contents by a third party. So it's now quite simple. If you're going to take a sports supplement, which you know will not place you at risk, you look for a label called informed sport or informed choice, which means that that supplement has been independently verified as being clean. So the manufacturers are obliged to send their batches over. That's in the UK, this organization. Obviously, there's a cost involved, but at least one knows that the risk is significantly mitigated in terms of taking anything which might be contaminated. And there have been high-profile cases of athletes that have tested positive, particularly for stimulants, but also for hormones, which have been taken in supplements which either deliberately contained those or were contaminated. So yes, on all three bases, deliberately cheating, clear-cut, medication that's prescribed, methods in place, and sports supplements now independently certified if you want to make sure that you reduce your risk.
That's very clear. It raises another interesting legal issue, Nick. So let's assume that there's an athlete out there and he's really, adhered to all of these protocols that Jon suggested. He's checked every supplement and substance that he takes, and he's verified that these are all sort of legitimate. They have the sort of green tick next to them from that point of view, and yet he still gets a positive test that comes back. I mean, what are his options in those circumstances? Does he just have to say, look, I accept the ban and I fall on my sword, or are there any options open to him if he genuinely, legitimately feels that he's kind of taken the right supplements, he hasn't gone and deliberately taken, anabolic steroids? What are his options at that point?
Yeah, I mean, that was exactly the position Mamabolo found himself in, because he had no idea how the substance got into his system. I understand that was a stimulant that one can get through these nasal decongestant sprays, but it can also be dissolved into drinks and that kind of thing. But to answer your question in general terms, the first thing is to try to figure out how the substance got into your system, and to scrutinize all of the supplements you've been taking and all of the medications you've been taking, and try to track it back so that you can present some kind of explanation to the authorities as to how it got there. And hopefully it was due to no negligence or fault on your part, and that will be relevant when it comes to the question of sanction. If you genuinely cannot determine how it got into the system, which it seems was Ludwig Mamabolo's problem, the legal strategy is to focus on potential deviations in the testing protocols, which might explain how your sample, could have become contaminated. And that was the strategy that worked for Ludwig Mamabolo. If there's nothing like that, in other words, if you don't know how it got there, and if the testing protocols were unimpeachable, and yet you still tested positive, you're up a creek without a paddle. And really, the best thing you can do is probably throw yourself on the mercy of the authorities and tell that story and put up as much evidence in mitigation of sanction as you can. But it is a very difficult position to be in practically from a litigation strategy point of view.
Jon, last question to you on the doping side. Do you think that there's sufficient education in South Africa, especially at our schoolboy level, around doping issues? And do you think there's sufficient awareness? And do you think that people are sort of fully cognizant of the consequences of contravention? That they could face a 4-year ban, that could be the end of a sort of promising young sports career. Do you think there's enough education out there about all of this?
There's plenty of education at many levels. SAIDS has education programs which they make freely available to schools, both online and face-to-face, which schools can buy into and have as part of their life orientation programs. And in this day and age, I think that really should be part of any syllabus. Each of the sports organizations has doping and supplement education programs. SA Rugby, as part of their Box Smart program, has an extensive program which is available again to all schools that participate in rugby or offer rugby, and which they offer at all of their youth weeks and to all of the provincial and national teams. And in fact, for athletes who are part of the SA Rugby setup at various levels, those become compulsory. So I do think that education is there. I think the education around the issue of supplements that I've mentioned is probably not as extensive as I would like it to see, that there are options that are safer, that mitigate against risk. But I want to mention two things. I think that where there are cases of anabolic steroids that are found in young people's samples, in my experience, over 30 years of involvement in this, is almost always deliberate cheating. So they've sought out that agent. And the second is the complicity of parents and educators in the process. It's very difficult to institute effective education if there are pressures and even bad advice coming from parents and from educators and coaches. And I would implore parents and coaches to take a very strict line on what's appropriate and what's inappropriate in terms of use. Very similar to what the way we talk about drunk driving. So you would not encourage your son or daughter to get into the car after consuming alcohol. And it's the same principles that should be applied to doping in sport. And I fear that in South Africa, we don't have that same uptake in terms of principle of getting that across to our young people. And I would like to see that adopted more strictly. So we can always educate better, but the material is out there. It's how effectively it's been applied in an environment in which sport is very high profile and pressured.
Thank you. Can we move to topic 2? Which is really a fascinating one for me, and one that I think we're going to hear some really interesting insights from both Jon and Nick on. And that's the case that's been brought against World Rugby by many former professional rugby players, and it essentially relates to head injuries. And the essence of the case, and I think there's approximately 1,000 former rugby and rugby league players that are suing World Rugby and the Welsh Rugby Union, the Rugby Football League. And essentially, the gist of this claim is to say that these organizations owed a duty of care to these players, and they failed to adhere to that duty of care by virtue of either the nature of the laws and regulations which didn't accurately prevent head injury, or secondly, that players weren't really properly informed of the risks of head injury in playing rugby or rugby league. I'm going to start with you, Jon, because I think there's probably a lot of parents out there who, when their child wants to play rugby, or this is a real sort of hot potato topic of conversation these days. And, parents are really concerned, should my child be playing rugby? Is there a serious risk of head injury? If they get concussed, does that sort of have lifelong consequences for them, and these types of issues? And I would just be interested, as a physician who deals with concussion as part of your daily practice, what are your sort of high-level views about the risk of head injury in a contact sport like rugby? And what would your general view in that regard be?
So we could go on for days, and in fact, we have conferences that discuss this. It is so complex, and the reason for that is that the brain is a very complex structure. So just to give you one figure, that there are 97 billion electrical signals given out by the brain every second. So that even makes AI pale into insignificance in terms of its complexity. So understanding the brain is something that's not easy. So does taking impacts to the brain, directly or indirectly, have an effect, and can it have a negative effect? Absolutely, both acutely and, if it's repetitive, possibly over the long term as well. But there are two aspects which people often don't discuss. So one is something called neuroplasticity, which is the brain's ability to recover, like a muscle can recover. The brain nerves can as well. And the other is cognitive reserve. So the fact is that you don't always use all aspects of your brain, and you may have an ability, even if there's some temporary injury to one part of the brain, to call on another part to function. So taking a single knock to the head has to be taken seriously, but does not mean that you're going to have permanent long-term brain or neurological issues. And I think sometimes there's a loss of perspective. Now, what the World Rugby case, and before that, the case in the NFL in America, brought to the fore is what are the risks of long-term repetitive knocks to the brain. And I think that is the discussion which is at the forefront of sports medicine, probably at the moment. Now, in terms of acute protocols, what happens on the side of the field where there's a knock? I think in the last decade and a half or so, we've made massive strides in terms of protecting our athletes' brains. And the Concussion in Sports group, of which I'm part internationally, has really led that process and worked with international sports organizations. And you will see now on the rugby field that players who are even suspected of taking a knock to the head are brought off the field and undergo a very standard analysis process, and are followed up after the game to make sure their brains are protected in that environment. Now, what happens if you're having several of these episodes, and over a career you might have had, which is not unusual, 8 or 9 or 10 concussions? And that is where the area of interest is coming in, because as you're aware, there have been some high-profile cases in rugby and other sports of athletes who've had really severe neurological disease, motor neuron disease and dementia. Very high-profile cases. So in South Africa, we're aware of Joost van der Westhuizen, Tinus Lanier, and then overseas, cases such as Steve Thompson and Lewis Moody with their neurological conditions. Really severe, really frightening. What is the cause of these? And the honest answer is we're not actually sure. But we think that repetitive trauma to the brain may have played a role in part of that, certainly. Now, whether that's the only aspect, bearing in mind that there are other millions of participants in contact and collision sport who have cognitively demanding jobs over the courses of the rest of their lives, is debatable. And it's probably much more complex than that. And if you look at the literature, the Lancet review, for instance, has identified about 14 different medical aspects which might contribute to neurodegenerative disease. And repetitive trauma is one of those. So in certain cases, the trauma may be a catalyst. It may be a significant part of the problem. but it's much more complex than that. And that's why the World Rugby case, or the case against World Rugby, I think is on shaky ground at the moment, because it's going to be very difficult to prove that it was participation in rugby and the care or lack thereof that those players received that resulted in their neurological state, which they're trying to prove. So it's a complex issue. I'll leave the introduction at that, and happy to delve into it a bit more.
So Nick, let's talk about the legalities for a second. World Rugby denies that rugby union carries with it a likelihood of head and brain injury. They seem to suggest that head and brain injury is a foreseeable risk in the sport, but those who participate voluntarily accept that risk. What's your view about those two issues?
I was listening with interest to Jon because my very nondescript rugby career finished in the mid to late 90s with several concussions along the way, as someone who was a bit small and probably tried to tackle a little bit too harder than my physique justified. And you know, in the 90s and the early 2000s, certainly in the rugby culture I was playing in, it simply wasn't known that this thing was such a significant risk. And that's what I think that's precisely what World Rugby's defense is going to be, is that the state of scientific knowledge at the time that these injuries occurred meant that for the rugby bodies that are the defendants, it simply wasn't reasonably foreseeable that participation in rugby could result in this kind of medical consequence down the line. I mean, that defense is slightly at odds with the other question you put to me, Anthony, about whether the players themselves could be said to have consented to that risk. That's what's known as a volenti defense. They also seem to say that the players should have known rugby is a contact sport. You take on a degree of risk when you play a contact sport like that. But you can't at the same time run a defense which says we as the authorities didn't know that there was this risk, but the rugby players should have known that there was this risk and did know and accepted that risk. So it seems to me those two things are slightly at odds with each other. But the litigation is hugely complex and it's run into some quite severe procedural difficulties. I think partly as a result of the fact that in the UK, they don't have what we have here in the form of a structured class action type of litigation. They have group litigation management. And what that means is that every plaintiff has to prove every aspect of their claim. And the reason it's kind of run into trouble now is because all of those thousands of players, some portion of them have failed to provide documents establishing what neurological diseases they suffer from. And the judge, the master who's running the litigation has adjourned to consider whether to strike out those claims as a result of that non-disclosure. And I see that they're changing solicitors firms as well. So it looks like it's running into some procedural difficulties.
Can we also talk about the sort of burden of proof in this kind of case? So even as you quite rightly point out, Nick, there are very material differences between their system and ours, and probably much easier in our system to prove a class action of that kind. And interestingly, I note that there's not a single South African player, I don't think, that's part of this action, which is interesting. But let's just talk about the burden of proof, because even under our system, you would have to at least demonstrate medical evidence across the class to show this neurological harm and to demonstrate that had occurred as a consequence of playing rugby. Jon, can we talk to you about the medical evidence? Because this seems to me to be quite difficult to demonstrate. I mean, there have obviously been a lot of studies which have been conducted primarily overseas, both in the United States, and I think there's one called the Glasgow Field Study that looked at various Scottish international rugby players and looked at the risk of neurodegenerative disease. And there was also a study done in 2023 by Glasgow, Boston University, and Sydney, which looked at post-mortem findings of 31 rugby union players, and they found the so-called CTE was in 68% of the brains examined. But it seems to me that one of the kind of difficulties with proof here is that your ability to establish CTE is generally only in post-mortem samples once somebody has died. So it's very, very difficult, and I don't know if it's even possible to show CTE in somebody who's alive. And Jon, can you just talk a little bit about the sort of the medical evidence in this kind of regard? Because I mean, obviously you could do a brain scan on somebody and you could show whether they have some sort of brain injury on an MRI scan or something like that. But to show CTE, which they've established in these post-mortem studies, seems to me quite difficult to show in a living person. I just wanted to get your comment on that.
Absolutely. Again, I'll come back to my original remarks that this is a very complex issue. So just to explain this concept of CTE or chronic traumatic encephalopathy is a series of histological changes or changes to the tissue of the brain, which can only be diagnosed post-mortem. So there are groups of pathologists around the world who've researched this. The biggest group is in Boston. There's also a big series out of Australia, which looks at the brains of retired footballers across different contact and collision forms of football. And they found a pattern in their brains which shows that there's an accumulation of a type of protein called tau protein in a very distinct way in the brain. And they've matched those to some medical histories in those athletes, some of whom committed suicide, some of them whom had depression, etc. And they've said, well, this pattern of post-mortem histological change seems to suggest that there's trauma to the brain in people who've had repetitive knocks to their heads. And you're quite right that identifying this while these athletes are alive is actually impossible. So one can have suspicions raised with certain behaviors, but we have to remember that mental health issues extend across a spectrum of conditions and affect not only sports people, but everybody may be subject to things like depression, anxiety, Parkinsonism, all sorts of medical conditions. And one can't look at an athlete who presents with some of these symptoms and say it's CTE. It's impossible. And that's the risk here, is that people are trying to make this a binary diagnosis, that if you present with certain symptoms, you must have CTE as an athlete. And that's highly risky, because you're going to miss a whole lot of potentially treatable medical and psychological conditions if you assume that. So it's a very complex process that we're working our way through in terms of the research, and what we're hoping to do is conduct more longitudinal studies. Now, that Glasgow study that you referred to was interesting because it did show a significantly higher rate of what we call neurodegenerative disease. So that would be things like dementia, Parkinson's disease, etc., in people that played contact and collision sport, in that case, footballers. And there have been similar studies published in rugby, in American football, etc. But what people don't know about those studies is they overwhelmingly show that those people that participate in those sports across a range of other medical conditions are actually a lot healthier. So they have lower incidence of things like diabetes, hypertension, cardiac disease, etc. As a result, they live longer, and many of those neurodegenerative diseases are recorded after 70 years of age, predominantly because that cohort is actually living longer because they are healthier. Now, that does not mean that repetitive impacts to your head are good for you at all. Obviously, as I mentioned at the beginning, that's one of the risk factors. And that's why the laws around contact and collision sports have changed considerably, and we're trying to mitigate impact. Nick referred to his playing days. He will have been quite aware of that South African tradition of kopperstamp, where you actually deliberately tried to take contact during training sessions. Now, those sort of trends are completely out of favor in today's training session. So we're mitigating risk. We realize that it's one of the contributing factors, but we also realize that participation in sports, including contact and collision sport, is actually good for you across a range of medical conditions. So it's a very complex issue. Mitigating contact and collision risk is important, but short of banning the tackle, you're not going to remove those impacts completely from collision sports such as rugby.
Nick, it's interesting, as I said, that there are no South African rugby players that appear to be part of this group action in the UK. Do you think that SA Rugby is potentially at risk for these types of class actions here? And is there a sort of lower threshold for bringing those cases here? And because of our constitution, do you think that it might be easier to bring this type of case in South Africa as opposed to the type of case that's being run in the UK?
There's certainly elements of our system which make it a more attractive jurisdiction for this kind of litigation. One of those is that the main fight in class actions tends to happen not at the stage at which the trial actually runs and all these elements are proven, but in the application for certification of the class action, where the applicants ask the court to certify them as a class, and they have to show that they have a prima facie cause of action, that there are common issues that can be decided in the class. And what almost invariably here tends to happen is that the fighting happens at the certification stage. If the court certifies, then usually the matter goes on to settle, because the defendants tend to have been given quite a strong sense that they're at risk, and it makes more commercial sense to settle it. So that's exactly what happened in the silicosis class action, where I was in that application for certification fight. That's one reason why it's more attractive. Another reason is that I think our courts have a more flexible approach to the question of causation. This issue of repetitive head traumas across a career causing a neurological condition at the end of the day is a really difficult one under English law, because it's very hard to isolate which particular collision under the auspices of which regulatory rugby body contributed ultimately sufficiently to you having this disease at the end of the day. And World Rugby and the defendants in the UK are making much of that, and saying, look, you can't say that it was your participation under the auspices of our competition which resulted in your disease. You also got head collisions when you were in high school, and there are other factors that contributed to it, which is really a similar defense that the gold mines ran in the silicosis case. It wasn't your exposure to dust in our mine necessarily that resulted in your silicosis. You worked at 10 mines across the course of your career. One can't isolate out the causation, and our courts have a slightly more flexible approach to causation, which says that kind of cumulative risk creation can be sufficient to establish liability. On the other hand, our kind of damages awards in this country tend to be fairly modest, and that may be a reason why the litigation hasn't run here.
Anthony, can I come in here and just talk to your point about the South African environment? Now, when the issues arose in the NFL and then in the Rugby Football Union in the UK, I thought that a proactive approach was appropriate by South African Rugby. So I actually approached the medical manager of SA Rugby and had this discussion with him. And we actually put out a call to our current and ex-rugby players through two organizations, one known as My Players, which is sort of the players' trade union, and the other called the Legends, which really represents retired players and keeps them in the game. And we asked them if anybody has any suspicion of any sort of psychological or mental condition that they think may be related to their participation in the game, should they come forward. And this is across decades of players. And we had one player that came forward. and he had certainly some genuine medical concerns, but his history was so complex and muddied by so many other different things, such as alcohol abuse, other forms of trauma, etc., a history of psychological conditions, that it would have been almost impossible to attribute it only to rugby. So it is interesting that in a country where the physicality of rugby has been so much part of our sports culture for decades, that we don't have this cohort coming forward and making claims like you've seen in the UK, Ireland, and America. I can't explain the reasons for it, but it is interesting that SA Rugby, who really does take player welfare very seriously, has made deliberate efforts to try and approach ex-players, and also put in place and brought into World Rugby's player brain health process, where players who playing the game or have played the game have access to a medical and psychological screening process free of charge, which can point them in the right direction in terms of their medical and mental health care. So there are significant processes in place to help support players which weren't there a decade ago.
No, thanks, Jon. Last topic for this morning, and we've got about 10 minutes till we have to wrap up. And this is a slightly more light topic than the first two we've been discussing, anti-doping and head injuries. And that's about player sanctions for disciplinary infractions on the rugby field. And I think sort of one of the pet topics of conversation, often from a South African point of view, is really inconsistent standards that are applied from a disciplinary point of view when it comes to disciplinary infractions on the sports field. And perhaps it's only just because as South Africans we are slightly biased, but it just seems to be that South Africa tends to get the rub of the worst types of disciplinary decisions. You know, our players tend to get very lengthy bans for extended periods, and for very similar offences, other players in other jurisdictions seem to get much lighter sentences. And one of the very obvious ones that comes to mind from 2 weeks ago, when the All Blacks were playing Ireland, All Black flank cleared out one of the Ireland guys using his elbow in a ruck. He got a yellow card. There was no further sanctions, and that was it. And one had to think that if that had been a South African player, the likelihood would have been of a red card immediately and a very lengthy ban, probably 6 to 8 weeks after the match. Nick, can I start with you on this topic? Because there seems to be this inconsistent pattern both on the field by the referee and also by the TMO when it comes to these kinds of findings on the field, and also by the disciplinary panels afterwards. And there seems to be very different sanctions that are meted out to players. If a player is facing a disciplinary hearing for a particular infraction, in your experience, is it open to them to say, but look at the way in which other disciplinary panels have treated very similar infractions, and to try to argue that there should be some mitigation of sentence or some sort of consistency in the way in which disciplinary sanctions are imposed, given the way in which other similar incidents have been treated?
Yeah. Look, I mean, Anthony, it's a very infuriating issue when you're acting as a player representative in these disciplinary hearings. There is a degree to which previous decisions can inform the decision maker that you are appearing in front of. And what one does do is one goes back, you can call it a sort of jurisprudence of past decisions, which World Rugby publishes. And when we do our player representations, we go and work through that jurisprudence, and we try to draw on it to persuade the panel that we are appearing in front of that this is the kind of infraction that should incur a certain kind of penalty. And so, I had a case which was about a crock roll. And so I went back and looked at all the sanctions imposed in cases of crock rolls and sought to persuade the panel that, look, there's a sliding scale of crocodile rolls. On the one end, you have very severe where downward torsion is placed on the lower limbs and which results in injury. And then on the other hand, you have the more kind of benign, just sort of rolling a player to the side without creating any reckless risk. And you try to persuade the panel that your incident falls on that sliding scale closer to the more benign side. But there is a limit to that kind of argument in these panels, because that jurisprudence, I've called it, is not binding precedent. It's previous administrative decisions dealing with similar issues, which they can take into account, but it has only persuasive and not binding value. And of course, the panel will say, if you point to, for example, the Luke Jacobson incident you were talking about, where he went flying in and then the TMO said, well, his chicken wing got trapped on the Irish player, and as a result, there was mitigation for him flying off his feet and smashing into the other guy's head. And so it wasn't upgraded to red, and there wasn't even a sighting. If I was to be in a similar position for a Springbok player and try to rely on that decision, what the panel would likely say to me is, well, yes, Mr. Ferreira, they probably got that wrong. We want to get this decision right. And so, leave that one behind. So it is rather infuriating. It's not good for the legitimacy of the decision-making process, but it has limited probative value when you're appearing before these panels.
Jon, can I turn to you on the last question on this topic? It seems to me that sometimes we neglect medical evidence in these disciplinary hearings. So for example, a guy tackles a player who's in the air and the guy lands sort of awkwardly, and they say, well, that was a very dangerous tackle. That guy could have had, very serious injury, and therefore we're going to, have a serious sanction, 6 weeks or whatever it is. Do you think that there's enough consideration given to medical evidence in these kinds of hearings, both from a player representative point of view and also from a disciplinary hearing point of view?
Well, I think in the context of our previous discussion over the last half an hour, probably not. And if we're looking at improving player welfare, both in the acute situation, contact situation, and in a long term, then we need to look at these things and say, right, in the context of this particular incident, what are the risks to the player, both in the immediate next few days and also over the course of his career? And perhaps that sort of evidence could form part of the disciplinary process much more than it is. And I think it should inform it if it's going to be part of our broader discussions in terms of player welfare and long-term health and well-being of players. Then we need to look at these situations, because a reason for the sanction is not really because it's necessarily just uncompetitive and unfair. It's because there is a degree often of medical risk. And exactly what you've said, those tackles in the air can be disastrous if that player falls the wrong way. Similarly, those severe head collisions are potentially very dangerous. Now, increasingly, we have the evidence to support those discussions. So we have video review, which is now from various angles, often 6 different angles. And the other thing is we have instrumented mouth guards. So all the professional players now wear mouth guards which have accelerometers in them, and we can measure the extent of the impact, which might give further information about how significant that impact was. So with modern technology, with our understanding of what potential risks are acutely and chronically, absolutely, we should be using that information. And after this call, I'll exchange cell phone numbers with Advocate Ferreira, who's welcome to call on me for future cases to help support his players who he's representing.
Thanks, Jon. Nick and Jon, we've got to wrap up. I'm going to ask you each in 1 minute if you've got any thoughts on today's discussion that you want to leave us with. And Jon, I'm going to start with you. Any last minute thoughts that you want to leave us with following today's discussion?
I'll just say that I think sport and exercise medicine for me is probably the most fascinating aspect of medicine because it draws together so many of the points that we've raised in this last hour in terms of not just medical aspects, but sports participation, and to an extent that doesn't permeate into other forms of medicine or disciplines, is ethics. So largely we're practicing in a field which certainly in professional sport is a public arena, and even at amateur level involves a lot of other people's input like parents, coaches, etc. So the decisions are often fraught by certain tensions and certain biases, and it takes sometimes a really clear head to make the right decisions in the interests of the player themselves. So I continue to learn, I continue to be educated by discussions like this because it is such a multifaceted field of medicine that extends far outside the consultation room itself. So thank you for inviting me. It was another fascinating discussion in an area that I continue to be invested in.
Thanks, Jon. Nick, any final thoughts?
Yeah, no, I mean, as a lawyer, this whole area is just so fascinating because of the such serious emotional responses that sports evokes in everybody who's paying attention to it, the huge financial incentives for various participants in the industry to act in certain ways, and the real importance of having a proper and legitimate system of dispute resolution and enforcement of the rules. So it really brings together, I think, all the best aspects of being a legal practitioner in a way that is revealing of human psychology, and it's a great area to be practicing in, and it's great to have discussed it with you guys.
Well, Jon and Nick, thank you very much for your time this morning. I know that your time is in short order, and there's lots of calls in your time. So thank you very much to both of you. It's been a great discussion this morning. I really enjoyed it, and I hope the people that watched enjoyed it. So thank you very much to both of you. Really appreciate it. Thank you.
Great pleasure. Thanks, Anthony.
Thanks, Anthony.